I grew into the school, I was given responsibilities that made me become a bridge between the students and the management. I did my Standard 7 in Luak Girls Primary School and I scored 33 points out of 36. I then went ahead and did my O-levels in Luak Girls and I scored a first division. I was called to Loreto Limuru, but the headmistress, having identified me as a good leader, implored on my father to allow me to continue in Luak, and I did. So I did my A-levels in Luak and I scored 4 principals and 1 subsidiary. And while in Luak, I contributed to a debate. It was a national debate on NATO, the North Atlantic Trade Organization. I was still very young and I managed to debate and I got a trophy for my school, which is still in the headmistress' office to date. After my A-levels, I joined the National Youth Service, where we were taught the attributes of patriotism and national unity. Initially, I wanted to become a teacher, but everybody around me told me I had to be a lawyer. So having been convinced that I could persuade, I decided to pursue law at the Nairobi University. While at the Nairobi University, I wrote my thesis on child health and the law, because I was concerned about parents who were not taking their children to hospital because of religious convictions. That was my dissertation. I then got my LLB and went to the Kenya School of Law. At the Kenya School of Law, I did my pupillage at Arch and Wilcock. And then my masters were Reg Simpson, the retired Judge Ransley, and retired Deputy Chief Justice Kaplana Rawal. But I was under the tutelage of Reg Simpson. I worked with him and he looked at me and he told me that he thought that I could do very well in the criminal justice sector. And he asked me to apply to the office of the Attorney General, and I did. And I was employed in the office of the Attorney General before I was admitted. I served in the office of the Attorney General from 1991. But I go back to my schooling days. Apart from the accolades and the high achievements that I had in school, the most important is that it was a Catholic environment, and it inculcated in me very deep godly values that have shaped my philosophy and relationships with others, socially and professionally. I have now come to realize that those values are the core principles and values of justice. These godly values have helped me cope with life. Every morning when I wake up, I recite the universal prayer, the litany of humility, and the prayer of St. Augustine, that remind me that I'm a mortal person and I live for the present, and I have to work on the inside of me if I want to impact other people and I want to impact my community. And those are the values that I've carried along. I joined the office of the Attorney General in 1991 and rose through the ranks, both at the Attorney General's office and at the office of the Director of Public Prosecutions. I then did my master's at the Nairobi University, and my master's thesis was the efficacy of retribution in post-conflict countries. One of my recommendations was that ADR, Alternative Dispute Resolution Mechanism, should be employed in a jurisdiction. And I specifically recommended that, apart from streamlining ADR, there have to be mechanisms to make them affordable and accessible to people. During my stint at the office of the Director of Public Prosecutions, I've undertaken several courses in management, professional courses, and leadership courses. They have shaped my skills and competencies. While at the office of the Attorney General in 1998, I was lucky to be selected to attend a course in Lund University on human rights. And them days, social and economic rights were not justiciable. So we had very little examples from East Africa. But when I came back to the AG's office, I continued with my prosecution. I prosecuted from the lowest court to the highest court, several offenses, culminating in my prosecution of the suspect of 1998 bomb blast in New York for 2 weeks. And what was at stake was conflict of laws, and I managed to help in writing victim impact statement assessment for the federal court in New York that ended up in reparation of some of the victims of the bomb blast. While at the office of the Attorney General, I have served in several commissions, several committees, both as a member and as a chairperson. And that has accorded me 2 heads of state commendation, from the late His Excellency Mwai Kibaki and Honorable His Excellency Uhuru Kenyatta. I've also been commended by my class and by the Law Society of Kenya. My lady, while at the Office of the Attorney General, and the DPP, I've contributed regionally, and this has shaped my experience. With the UN, I was one of the experts on the 10th anniversary of the UN, who codified the Transnational Organized Crime Digest, and my name is at the back. Then I was serving as an expert in piracy and maritime, and I had opportunity to visit many jurisdictions, many common law and civil law jurisdictions. I was interacting with law enforcement agencies to collect cases, to analyze them, and to make them part of the digest. Still with the UN, in 2016 I was called as an expert in the Security Council when they were adopting a protocol to speak about judicial cooperation in organized crime matters, and I did it, and I've attached the paper that I gave. Apart from the United Nations, I have worked with the Commonwealth. I was one of the 3 experts who reviewed the Harare scheme on mutual legal assistance and recommended its amendment. I've also worked with FATF, that is Financial Action Task Force, which is an organization, a body that sets standards on money laundering and counter-financing of terrorism. Because of that background, I have taken part in training. Recently, I have trained the prosecutors in Zambia and Tanzania, and currently I'm working to come up with regulations for the Republic of Seychelles on regulating of cryptocurrency. My lady, Chief Justice, if I was given an opportunity for this post, I bring a wealth of experience from diverse contexts. I have strongly trained in management and leadership. I have strong communication and interpersonal abilities, problem-solving capabilities, acute decision-making character, which I have gained through my friends and my association. If I am selected for this position, I will be able to fill some of the gaps that I've been seeing as I have been part of the NCAJ. 2 of them I would like to mention. I will be able to help the judiciary deal with the backlog of cases because there is delay of dispensation of justice. And justice delayed has been perceived or can be perceived to be justice denied. I will therefore work with my colleagues to help in the efficiency of that in that area. Secondly, taking into account that I'm in the criminal justice system, we are independent, but acknowledging our interdependence. I will work together with my colleagues to make sure that we have dialogue, roundtable dialogue with stakeholders, so that we can demystify the Court of Appeal. And in doing that, we will be able to bring the stakeholders together with us, so that we can identify areas where we can work together, because nobody can work alone. While at the Office of the DPP, I have contributed to the transformation of the Office of the DPP. We left the Attorney General's office in 2010 when we were only 93 prosecutors. I have worked on policies, I've worked on guidelines, the structure of the office, HR manuals. Currently, we are a staff complement of 1,300 who are all working under me. We every year take 100 pupils and 60 interns. We take 100 attaches, and of late we have been taking legal interns, taking into account that we have many people who had gone to the Kenya School of Law, but because of one reason or another, they have not been admitted as advocates of the High Court.
I think now we are getting deep into the questions that my colleagues will be asking you, the specific questions, and I think we better go into them.
Thank you.
Just deeper on the leadership. You are in a position of leadership at ODPP, and you recognize that the Court of Appeal is reeling on the weight of the backlog. But maybe one question the commissioners would like to hear from you is how you're going to navigate this new area. You've just been dealing with the criminal. You come and find a backlog of cases, some of them criminal, civil, commercial, succession, land? How are you going to fit in that Korengio atmosphere?
My Lord the Chief Justice, I stand to be corrected, but the Court of Appeal is not a specialty court. It deals with all aspects of law. Secondly, although I have been in criminal, from my work in the office of the DPP, I recognize, and I would like the Commission to recognize, that with development in law and criminal law internationally, there is a very thin line between criminal and civil. There is a thin line between common law and civil law. There is a very thin line between criminal procedure and civil procedure. And in most cases, we find that all the criminal justice agencies interact in dealing with modern crimes, investigation, prosecution, and adjudication, interact independently but interdependently. While I was working for, I was appointed to be an assisting counsel in the Tribal Clashes Commission. It was led by 3 judges, 2 from the Court of Appeal and 1 from the High Court. I was there for 2 years. The issues we dealt with were not just criminal issues. There were issues touching on all areas of law. These were 3 judges that were working like a member court, which has 3 judges and 2 assisting counsel, but I was part of them. From that experience, I learned what it means to work together as 3 people. Secondly, I was exposed to other facets of law other than criminal law. In fact, we were dealing with issues of land, what we would call today socio-economic and political rights. We were dealing with issues of access. We were dealing with issues of marginalization in the Tribal Clashes Commission. And during that commission, I was exposed to other things in society, especially marginalization, the right of children, the right of women. It was one of the most horrific situations to put somebody who was as young as me. But I have commendation from Justice Akiwimi, which I've attached. He has said that I assisted tremendously, and I was impartial, and I did my work with diligence and competency. Secondly, when I served in the Goldenberg Commission, it was not criminal as such. There were issues of procurement, issues of trade, international trade. And we had to undergo a course as a commission led by Professor Ryan so that we could understand the nuances and the issues that were in that commission. And I served it for 2 years. And I believe that while I was serving as a junior person and assisting counsel, there was impartation of knowledge from the 4 assisting counsel that I had, who were, 2 of them were senior counsel and 2 of them were senior advocates. While in the office of the DPP, what I have been dealing with mostly, although it is formally policy formulation, but I have been exposed to other facets of law that I've not been able to, that I would not have been able to interact with if I was not in the office of the DPP. So my answer is that I am a person who is ready to learn. I have the capacity to learn. I have experience to know where the law is. The majority of cases that come to the magistrates' courts, out of 335,000 cases that were registered last year, 250 are criminal cases. And although most of them might not end up in the Court of Appeal as criminal cases, aspects of them, because now in issues of investigation, judicial review, aspects of criminal law are entertained inside those issues. I therefore believe that with the experience that I have, with the skills and competencies that I have achieved, I am able to learn, I am able to apply what has been put before me for application and interpretation. I'm also able to rely on my colleagues who would be senior in that court to learn the journey through them.
Thank you, Honorable CJ and the Chair of this Commission and the proceedings. My questions will dwell on particularly the theme or topic of integrity. Leadership first, leadership generally. In leadership, one of the core values in leadership are matters touching on integrity. In fact, integrity is a constitutional value under Chapter 6, also Article 10, Article 73 of the Constitution. They all relate to integrity. In the Court of Appeal, I was reading the Court of Appeal strategic plan, and just to re-emphasize the importance of that integrity, it says the vision of the Court of Appeal, the ultimate custodian of appellate justice delivered with fairness, ease of access, emphasize that, integrity, effectiveness, responsiveness, transparency, and accountability to all. As a prosecutor, I've seen your CV. Really, it's quite impressive what you have done and your leadership in various aspects. What are your thoughts about first as in prosecution, prosecutorial matters, and also in as regarding the job of a judge of the Court of Appeal? What are your thoughts about integrity?
Thank you so much, my Lord. Integrity is a core value, first of all, under the Leadership and Integrity chapter in the Constitution. Secondly, integrity is a core value of every person's life. As a prosecutor, integrity is one of our core values. I am called upon to be a person who can be accountable for my character, both in private and in public. I am called upon to be vigilant of issues of conflict of interest. I am called upon to be vigilant that my integrity does not impede dispensation of justice, and that as a leader, any activity that I do, I should bring honor to the office that I represent. I therefore say that integrity is a core value in the Constitution, in the Code of Conduct of the Office of the ODPP, in the Code of Conduct of the Judiciary, in the Code of Conduct of every citizen and public officers. I'm therefore saying that it is very important. It can interfere with the independence of every public officer and therefore must be protected.
Thank you. The Honorable CJ has asked you questions about, and you have answered quite, I would say, quite well about that having been mainly in prosecution work, but there are many other aspects of the law that make that you have studied and that you have been involved with, that qualify you to be able to be a Court of Appeal judge or a judge for that matter. I've seen that you have been chair of many institutions, particularly within that sector, and it's very intensive what you've got, what your leadership involvement. Regarding your wish to come to the Court of Appeal, what vision do you have? What because in any leadership, and Court of Appeal is a leadership function or office, what visionary ideas would you wish to contribute to the Court of Appeal?
In the Court of Appeal?
Yes.
I would wish to...
That's where you want to go.
Yes.
Yes.
I'd wish to contribute to transform myself first, and to transform the court, and to contribute to transformation of the judiciary.
Yes.
In the Court of Appeal, I will contribute my skills and experience to assist in dispensation of the matters that are within the jurisdiction of the Court of Appeal. I will also leverage on my association. I will leverage on my competencies and skills. I will leverage on my ability to learn, and I will leverage on my ability to inculcate in myself on a daily basis the laws that I need to apply every time that I'm called upon to adjudicate. So it is my experience, it is my association, it is my skills,
Yes, thank you. Have you, as I've said, I've seen what you have achieved as a leader in various sectors of the entire office of the AG and also of the DPP. Have you had any leadership roles elsewhere in society?
Yes.
Yes.
I am a leader in my church.
Yes.
I am a leader in my church. I go to Karen Catholic Church. I am a leader in my church. I am a leader in the estate where I stay. I am a leader in my school alumni. I am a leader in my home. I am a member of some boards of schools where I am a leader.
Yes.
And I am a leader in my family. Yes.
Yes. You must have come across the vision of our Honorable CJ when she took office about a year ago, when she launched the vision of her tenure, judiciary's social transformation through access to justice. How would you interpret that?
First of all, thank you so much, Honorable Judge. Transformation is transformation of the person who leads and the institution and the people that the person leads. I will be part and parcel of the agents of transformation. Social justice is access. It entails equity, it entails access, it entails issues of rights, it entails participation. If I join the judiciary, I will leverage on the experience that I've had in the office of the DPP, because even in the office of the DPP, we have a transformative charter of excellence that is directing the works of the ODPP. I will therefore use the experience and the skills that I have, the management courses that I have gone to, and the growth in leadership that have led me to learn about participatory leadership, motivating people I work with, assisting the Chief Justice in helping people access justice.
Thank you. Lastly, I've come across your sample ratings, and I'm not concerned about the skills of writing, but the topic that you presented. Was it a booklet or a paper, which I'm very interested in? The effectiveness of prosecuting traffic offences.
Yes.
Yes, I've read. I'd had. I just went through that in a casual manner that document or book, and I think that is a extremely well done document. And also the topic. The topic is very important. Traffic offences and the traffic law are not totally of a criminal nature. But I'm happy that you're dealing with it. You have dealt with this and considered it. And even the issues that you have dealt with about criminalization of the traffic law and the traffic sector. We have this problem of the boda, which has been now become quite a chaotic area of transport and industry, and I'm happy that you have attended to some of those problems. What do you think? What do you think is the way forward in dealing with the menace of the boda? The way that many of them are not trained, the way that the boda is actually being used as a weapon to mug people, to steal, and even to murder, and then the issue of observance of traffic law, all that you have written about here. What is the role of, say, the justice system, for instance, to deal with these problems we have in the traffic sector?
Thank you so much, my Lord Judge. First and foremost, as the Office of the Director of Public Prosecution, we deal with prosecution, which in itself is post-mortem, because the offense would have been committed. And when we charge people in court, we are supposed to use the legislation as it is, because it is Parliament that legislates. So our hands are tied with the legislation that we have. However, we have tried to go out of our way to look at which ways can be effective in us prosecuting traffic cases and what can we recommend. Off the mark, what I can say is that we have laws, but the problem is implementation. We have sufficient laws, but the problem is implementation. When it comes to registering of borders, we find that most of them are riding borders without registration, and that is an offense. But nobody is superintending over that. When it comes to not wearing helmets, not having identity cards, we have laws that deal with most of these things. So I would say that first and foremost, it is the problem of implementation. Until these people have acquired impunity, they do not care about law enforcement. But it has become a societal problem. And if it has become a societal problem, it behoves all agencies within the criminal justice sector. And this is one of the things that can be dealt with in the NCAJ, because all the agencies are represented. The gaps that we found, we presented them before the NCAJ so that every agency can pick what is concerned with their operations, and they can see how they can strategize. But as the Office of the DPP, we flipped out three things. First and foremost, we carried out that research because we found that traffic cases were more than 50% of the cases that we were dealing with. And we wanted to know, how come these cases are not going through the system? And should we take a long time dealing with these cases? And we kept on having repeat offenders. Then we found that we were dealing with very petty offenses. Most of the offenses were petty, and they could be dealt with by other mechanisms. For example, touting, not wearing a uniform, non-moving offenses that can be dealt with by other alternative institutions, for example, SACCOs and everything, so that we can reduce the number of cases that go to court. We also found that our punishment for traffic offenses was quite high compared to Rwanda and Tanzania, and therefore many citizens do not want to comply because they cannot afford to pay the fines. We also found that sentencing in traffic cases was not having an effect on people, because every time they would just pay the fines, but there were no ancillary orders on them. For example, you don't drive for 3 years. So it was just like a trade. So we looked at it and said at the Office of the DPP, what can we do? We found our weaknesses and we are trying to work on it, and we placed the report before the NCAJ, and we hope that we will work together. There is a committee working on it to find out solutions to that.
Thank you very much. That will be all from me. Thank you.
Yes.
Thank you very much, Honourable Chair. Learned Chair Council, I am not going to ask you to define or tell us what you know of judicial philosophy, but you may be aware that the liberal judicial policy, often referred to as judicial activism, has been associated over time with interpreting the law as it ought to be, as opposed to as it is. The question is this, Senior Counsel: do you think that this undermines the doctrine of the separation of powers?
Thank you, Honorable Attorney General. The interpretation of the Constitution is the purview of the judiciary. Parliament legislates, and the judiciary is supposed to interpret the laws and apply the laws to citizens. A constitution that has in it fundamental rights, freedom of people and liberties, socio-economic rights, already attracts the judiciary to look beyond the text. And if we look at our constitution, it provides mechanisms and framework of how our constitution should be interpreted. as long as the judiciary is upholding the law, developing the law, upholding the rights of citizens, freedoms and liberties, there will not be friction or interference with anybody.
Thank you. What of where the judiciary, for instance, restricts or prohibits another arm of government from exercising the very mandate that that arm has under the same constitution? What would you say to that?
If the judiciary is upholding the principles and values in the constitution, the judiciary is enhancing and protecting the fundamental rights of people within the constitution and the Bill of Rights, the judiciary would be right.
So which school of philosophy, judicious philosophy, would you say you belong to?
I would not want to be caged into a philosophy, because philosophies are developed by people. But as a Kenyan and as a prosecutor, I am required to interpret the law and the constitution according to the framework and the provisions within the constitution. If in interpreting those provisions, they will lead me to any philosophy that somebody would define, then so be it. However, I can confirm, and I'm ready to be corrected, that our constitution has given a multidisciplinary approach of interpretation. It is not possible to confine it. And I will also say that the Kenyan people, through the constitution, chose to give the judiciary power to look beyond the constitution, to interpret the constitution because of the provisions within the constitution. One of them is where the judiciary, a judicial officer, is expected and required to take into account the history, socio-economic situation of our country, is supposed to take into account issues of marginalization. Those issues cannot be found within a constitution. You have to go outside the text of the constitution. So if you do that and somebody calls you an activist, what matters is the consequence and the value that you are upholding.
Thank you very much.
Secondly, I wanted to say in the same constitution, there are provisions that are very clear, especially, for example, about numbers. It says that we shall have 290 seats in parliament. That is very clear, and there is no need to go outside it. So sometimes the judiciary will interpret that as it is, and issues of jurisdiction. So if you want to say that the judiciary is restrictive, they are just applying the constitution as it is and upholding the values and principles within the constitution.
Thank you. Just one more question, Chair. I'm familiar with the Judicial Code of Conduct.
Yes.
And with the Bangalore principles.
Yes.
If you do become a judge, what will be expected of you under the Judicial Code of Conduct and Ethics 2020 in relation to the independence of the judiciary? And that's my last question.
As a judge, I am required to uphold the principles in the Constitution. The Constitution provides that the judiciary shall be independent and shall make independent decisions. I shall abide by the Judicial Code of Conduct, Public Service Code of Conduct, and the Law Society Code of Conduct. What is expected of me as a judicial officer is to protect that independence. Some things are beyond me. For example, institutional independence, as opposed to the independence or the right and the workings of the executive and the legislature. So there is the independence that is institutional, but there is also individual independence and decisional independence, where I will be called upon as an individual to exercise independence in dispensing justice. Independence not only from something or somebody outside, but also independent from internal issues that might interfere with my independence in dispensing justice.
Thank you, Senior Counsel. That's all from me, Honourable Chair.
Thank you, CJ. I have no question for Senior Counsel. I wish you well.
Thank you, Chair, and good afternoon once again, Senior Counsel. I just have probably one or two questions. The first one is about arbitration. You're familiar with the Arbitration Act?
Yes, I am.
And the arbitration process?
To some extent, yes.
Yes. Give us 3 examples of how the Arbitration Act promotes autonomy of the parties to settle the dispute on their own.
Under the Arbitration Act, there is a provision which gives power to the arbitrators to limit their jurisdiction or to identify, articulate their jurisdiction within an arbitration. Secondly, once parties have agreed to be subject to an arbitration, the arbitration award is binding on the parties. And the Arbitration Act provides that you cannot appeal once you have subjected yourself to that, except on issues that are under Section 35. So it insulates the award, and secondly, it gives the arbitrators right to draw their jurisdiction within the arbitration.
So how do those demonstrate the parties' autonomy vis-a-vis the power of the court?
Because the parties voluntarily subject themselves, agree in a contract clause to be subject of arbitration.
Okay. Now, the second issue, you are familiar with the Insolvency Act, insolvency law.
Yeah.
Just tell us, what is the purpose of insolvency law?
The purpose of insolvency law is that if you are a going concern and you can no longer be a going concern for one reason or another, it protects everybody who is dealing with you for purposes of loss and damages.
So we passed an Insolvency Act in 2015. What was the key policy consideration stated in that act?
I have not interacted with the amendment.
Okay. Finally, you wrote about children. There was something, the government of the Republic of Kenya passed a moratorium on international adoptions. Are you aware of it?
Yes.
In your view, are there any constitutional issues arising out of that moratorium, and what would they be? Probably by reference to specific sections of the Constitution. Tell us what would be the issues in your view.
First, one of them would be, under the Constitution, a child has a right to adoption. It will therefore be limiting the rights of children to adoption to parents who would be suitable for them. Yes.
So what is the problem with that moratorium? What was it supposed to deal with?
It was supposed to deal with issues of the capacity and the integrity of people who are adopting out of jurisdiction who are not subject to the laws of Kenya.
Basically, it was to deal with the issue of child trafficking.
Yes.
So, if a child has the right to suitable adoptive parents, and the court is to consider the best interest of the child under the Constitution, what would be the problem with the moratorium?
I think every case will have to be dealt with on a case-to-case basis.
And what provision of the Constitution would you refer to when you're considering the moratorium, and whether it applies to that single case?
I would consider the right of the child to associate, the right of the child to have a family, the right of the child to grow in an atmosphere where they have an equal opportunity to grow.
Basically, you're talking about a limitation. The moratorium is a limitation of rights, isn't it?
Yes.
So which provisions of the Constitution are you looking at to determine whether that moratorium is reasonable or warranted?
The right of development of a child.
Okay. Probably we can look at Article 24 on limitation of rights, see whether it is reasonable and the factors considered therein. So thank you very much.
Thank
you. Wish you well. Thank you, Chair.
Honorable CJ, just 3 questions, general questions. I'll just ask you general questions. Now, in your view, what do you think would be the role of law in influencing culture of a people?
Culture and people's culture is protected under the Constitution as long as it is not inconsistent with the values within the Constitution. But law can protect those cultures by enhancing or protecting the attributes of that culture.
Now, I'm not sure there's no right or wrong answer in this. Whether we as a people now, aside from where we come from, of us as communities, whether you think that we have a culture of Kenyans, what you'd call now this the culture that is associated with Kenyans. And sometimes I get a feeling that there's also the danger of impunity that seems to creep in within our society. Now, in being a player, of course, in the criminal justice system, what role do you think judiciary would play in curbing this complaint by members of the public that there's also impunity amidst many of us, big or small, because it seems to be something that is also cutting across many of us, as Kenyans?
By the judiciary upholding the rule of law and applying the laws equally to every citizen, and being courageous in articulating where legislation or policy is inconsistent with the values within the Constitution. If in making judgments and pronouncing judgments, the judicial decision enhances the culture of people and protects what is good, and finds inconsistency in some of the cultures, writes it out, then the judiciary would have contributed, the law would have contributed.
Okay. Now my final question. Now, in what you've just said, do you see a place for doing exactly that in the Court of Appeal? And if you do get this position, how do you think you'll be able to shape jurisprudence geared towards realizing, the objective that you've just articulated?
The Court of Appeal exercises appellate jurisdiction over the High Court. However, when sitting over appeals and a case is laid before the Court of Appeal, which is positive in protecting and enhancing good culture which is not inconsistent with the Constitution, I will try as a Court of Appeal to uphold that, knowing that the Court of Appeal is the last court in many issues. It creates precedence that binds the lower court. Where possible, I will try with my colleagues to be clear on those issues, to pen down guidelines and decisions that influence the culture in a positive way, but within the confines of the Constitution.
Greetings once more, Senior Counsel. I have worked with Senior Counsel at NCAJ, yes, and I know she does a good job around there. So I have 2 questions. One is, there is a general perception that the judiciary does not have a hand when it comes to development, and at the global level we have the SDGs, and at the African Union level we have the Agenda 2063, and it is said that the judiciary is an enabler of those 2 development agendas. Could you maybe tell us what the judiciary can do towards realizing the two agenda, the UN level and at the African Union level?
At the UN level, out of the SDGs, number 16 requires a jurisdiction to have strong institutions of integrity and strong institutions that can stand for the economic development of the people. Now, the judiciary, by adjudicating on cases expeditiously so that parties can know their right, by adjudicating on cases judiciously, will attract investors because they will know that if they have a problem in Kenya, their cases will be dealt with judiciously, expeditiously, and in a manner that is not inconsistent with the Constitution. Secondly, the judiciary, in penning down or in issuing judgments, can make sure that those who break the law or make the environment or the atmosphere not conducive to the realization of those values or principles or protocols are taken into account and they pay for it, so that there is a level playground and a clean playground for everybody to exercise their right and to develop.
Okay, thank you. Recently, in the Mitubel decision, the Supreme Court ruled that structural interdicts are applicable in Kenya and proceeded to give guidelines on what the courts should consider before granting such orders. Could you please maybe give us 3 of some of the things the court must consider before granting such orders?
Such orders are granted by the court because the court would not want to give decisions, rights, or judgments that cannot be effected or that are in vain. So the Court of Appeal ruled that before such orders are given, they have to be given sparingly and in very deserving situations, and the court must be concerned with the capacity of the person the order is directed to, the capacity of the person to satisfy the order. The judicial officer must also be concerned with the time it will take for the order to be effected. The judicial officer should also be concerned that the order is time-bound, can be done within a certain period, is not open-ended.
Okay, I think that's enough, but I would urge you to still go back to the decision and look at it. And sorry, I said I have 2 questions, but I have to ask this based on your sample writing that you have shared. The remand action plan, I must say it's a well-written document. If you considered for this position, what are the best practices from this action plan and its implementation can you bring on board to the judiciary?
Thank you so much for that question. Expeditious disposal of cases. From the remand action plan, we learned that if case management is not properly effected, such that by the time people go to court they are ready to proceed, we have many adjournments and people take very long in remand. So case management and pretrial procedures, if they are effectively implemented, they will help in the backlog of cases. Another thing that was very fundamental in that report was that we found that many people that were languishing in remand were not represented and they were young. Therefore, the issue of legal aid to the people. And I am thinking that if it is possible, the Honorable CJ had directed that every case where a child is in conflict with the law, the child should be represented. One of the things that I would help in or contribute in is to make sure that if there are cases before me where a child is involved and there is a guideline that the child should be represented, then I'll make sure that the child is represented. Secondly, the Constitution requires that when somebody is going to be prejudiced by the trial, then the court can find that this person should be given legal aid. So the issue of legal aid if it can be extrapolated so that it can be adopted by everybody, it can assist. We also find that there are so many advocates who have advocates who actually should be working, but because of the situation that we are in, they are not able to get work. So if we could operationalize legal aid and public defender, most of our prosecutors, most of our advocates who do not have work might just have a second or third organ that can employ them meaningfully, and they can contribute to quick disposal of cases both in the small claims court and in other courts.
Okay, thank you very much, Senior Counsel, and wishing you the very best. Thank you, Chair.
Thank you, Chair. Just one or two issues that we need to discuss. Senior Counsel, in your opening remarks and in response to all the questions, you talked about a round table conference on stakeholders in case you get the position of the judge in the Court of Appeal. In that round table conference of stakeholders, would you share with us 3 key stakeholders will be sitting in that table? We'll be discussing issues of the Court of Appeal. Just 3 of them.
3 of them will be the Law Society of Kenya,
The Law Society of Kenya,
the Office of the Director of Public Prosecutions, the Office of the Honorable Attorney General.
Okay. Let's look at the Law Society. What did the Law Society expect from the Court of Appeal?
Thank you. The Law Society expects quick dispensation of justice. The Law Society expects a bench that acts with decorum, that has integrity, that will uphold the rule of law, and a bench that will decide according to the facts and the law before them, and that is professional. That is professional.
And I see, as a judge of the Court of Appeal, and I hope they give you the position, what do you expect from the Law Society as a judge now?
I expect from the Law Society professionalism. I expect from the Law Society cooperation. I expect from the Law Society preparation, so that when they come to court there is no adjournment.
Okay.
I expect from the Law Society proper contribution, so that we can both develop jurisprudence.
Oh, very good. I will not ask you about the principles and the values of public service, because I know that you are very familiar with them, and I've seen your work on them. But my interest here would be on the issue of the devolution of services. I know you are doing a very good job here at the headquarters in the office of the director. What of the outer stations? How are they benefiting from that experience that you are doing here? How are you castigating that professionalism to the stations out in the countryside?
The Office of the Director of Public Prosecution is in the headquarters. We have now created 8 regions to cover the counties in the Republic. We are in all the 47 counties and in the all 130 court stations. In all the courts in Kenya, we now have prosecutors who are professionals, who are lawyers, and the DPP is firmly in charge of all the prosecutions in Kenya. We, in the Office of the Director of Public Prosecutions, continuously increase the capacity of our prosecutors.
Senior Counsel, I want you to be very practical, because we live in this country.
Yes.
And I have been to your office in my local county.
Yes.
To the Office of the Director.
Yes.
Which is in some kind of, I think down is a bar, up is the office.
Yes.
And what I saw is different from what you're telling us. So how often do you visit these stations to make sure that they are in harmony, professionalism, as you do here?
Yes.
I will not name my county, but
yes.
if you decide to look at it, you can look at it and see what I'm saying is true.
And I do agree. I do agree, sir. When we came from the office of the, when we were separated from the office of the Attorney General, and we became independent, we had to operationalize the office, and immediately we had to take over all prosecutions in the lower court. We found that most of the offices that are in the counties, we already had leases. We also found that it was going to be very expensive to us moving people around. So what we did is that we came up with a model office. And this model office, we are trying to replicate it in every region, and county. It is unfortunate that because of devolution, some towns or cities were not well developed for us to get sufficient or adequate or appropriate housing for the Office of the Director of Public Prosecutions.
Okay.
But I can assure you that with the regional offices now, we are employing administrators in all the regions. One of their priorities now is to look at all offices of the Director of Public Prosecutions and see whether they match the ideal office that we have come up with.
Okay.
We're also working together with the judiciary. They are giving us offices in most new court stations that have been built.
I do hope that they have this set of excellence that you talked about earlier on. If I walk to that office, I can find it there. Is it true?
Yes.
Good. My final question is on a collaboration. You are the Director of Public Prosecution. Essentially, you are the Secretary. The buck stops more or less at your office. How are you promoting coherence, collaboration with the other government agencies as you execute your duties? I don't want to name some of those issues, but in public domain, that we need harmony in government, we need harmony in operations, because we're all serving Kenyans. How are you promoting that collaboration within government agencies that you're working with?
As the Office of the Director of Public Prosecutions, we take part in all the committees. One of them, we are active members of the NCAJ, where all the criminal justice agencies are members. And we are expected that if there is any disagreement or friction within those agencies, they are brought before the NCAJ and they are dealt with.
And you discuss them there?
And we discuss them there.
How come that you see them in the newspapers the following day?
Honorable Commissioner, from where I sit from, I have attended the NCAJ. I have been with the Honorable Chief Justice and the Attorney General. I am aware that all the issues we have regarding the exercising of our core mandate have been put before the NCAJ, and they have been dealt with, and if they are not, they are being dealt with.
Okay. Thank you, Chair. Thank you, Senior Counsel.
Thank you.
Thank you, Chair. Good afternoon, Senior Counsel. I have two questions to ask. One is on corruption. When it comes to corruption, many say that judiciary is the weakest link in fighting corruption, and but others who are pro-judiciary say that it isn't judiciary, it is they only deal with what they receive. And since you are from Office of the Deputy Public Prosecution Office, I wanted to understand from you if you are in agreement that judiciary is the weakest link, and having in mind the weakest link theory, which always states that the action taken by an institution is as a result of the action of the other, and is affected by the one that comes before it, which means you come before judiciary. So judiciary is dependent on you in whatever they are doing. That the results from judiciary is dependent on the input from ODPP. I wanted you to tell us a story around it, and as you are doing that, you can go ahead and, if at all there are gaps that needs to be worked on between the office of the ODPP and judiciary, what are these, and what are the proposals that you may recommend so that there is a smooth operation and cooperation between the two.
Thank you for that question. I would like to put it on record that corruption is a problem in the judiciary, corruption is a problem in the ODPP, corruption is a problem in all the agencies, and that is why in all the strategic plans and policies that you will see, there is a strategic objective of dealing with corruption and accountability. And I have checked the strategic plans of almost all the agencies within the justice sector and within the executive. There is a priority and a goal of dealing with corruption, and it has been stated nationally. So it is a problem in all the agencies, but it is not the problem it is a problem in the judiciary, but it's not a problem of the judiciary. It's a problem of all of us Kenyans, and it's a problem of the international community as a whole. We are independent, the judiciary is independent, but we are interdependent. When matters come to the office of the DPP, we make sure that we handle those matters with integrity and we apply the law. The work that we do, it is inescapable that you will find for one person and not another person, and somebody will blame you and say that you are corrupt because you have exercised your discretion, and mostly we exercise it according to law. The same thing with judiciary. When we take matters before the judiciary, they make decisions depending on the matters, the facts that are before them and the law. Somebody who is aggrieved will not be happy with the decision of the judiciary, and if you are aggrieved and you are rightly aggrieved, you have a right of appeal. However, we cannot escape blame. We are trying through the NCAJ, first and foremost, to expedite corruption cases. Secondly, as the office of the DPP, we have put up prosecution teams to make sure that by the time we go to the judiciary, we have cases that are viable, that are valuable, with a high prospect of conviction. We have undertaken joint trainings. We are making sure that in our trainings we bring in the prosecutors, investigators, and experts to help us bring simple cases that are understandable. And when we go to court, even after conviction, we try to ask for ancillary orders so that the punishment meted by court can be a deterrence to everybody who is involved in corruption. So each one of us is using our independence according to the Constitution, but realizing our interdependence, we are working together to make sure that the procedures are of integrity and what is churning out of our institutions is within the law.
Thank you, Senior Counsel. Thank you, Chair.
Thank you, Honorable CJ. Senior Counsel, I have two questions. One is just observation from your CV. From 2007, 2008, 2010, a lot of trainings. I'm counting like probably 5 or 4 times a year. So my question is, and of course there's nothing wrong with training because it helps us grow and we benchmark, but are there too many, or is it that there are so many opportunities you have had as you go up the ladder?
In the office of the DPP and then in the office of the Attorney General, some trainings are group trainings, some trainings are individual trainings, depending on the position you are in. For example, for about 10 years I headed the Transnational Organized Crime Division, and that time we were still developing laws, and we had a lot of emerging crimes, so it required us to undergo a lot of trainings. But secondly, in the office of the DPP, there is a policy on succession. If we have identified 2 or 3 people who can be accelerated in management and professionalism so that they can take up managerial positions, they got the training. But everybody in the office of the DPP is well trained.
Okay, thank you for that answer. My second question is, there's this concept we keep talking about emotional intelligence, and my question is, do you think people are born with it or it is developed over time?
It is both.
It's born?
It is both.
It's both. Just
yes.
Explain a little.
Some people have attributes that endear them to people, and they can learn people and work together with people, but part of it has to be learned, and it can be imparted, and it can be transferred through trainings, capacity building, and mentorship.
Good answer. Maybe you can explain to us, Senior Counsel, how then you have used it. I'm sure you have it. How have you used it in leadership? Because you have had so many leadership positions.
Invariably, in the office of the Director of Public Prosecution, we work with teams, and we have got very many people from different backgrounds, and it is important as a leader that you look at everybody as an individual and try to help the person together with the person to identify their needs, both professional, individual, and sometimes even outside the office, because they affect the way they act within the office and the way they discharge their mandate. So I have used it by being close to the people that I lead. They have impacted me, I have impacted them, and wherever I can pick a gap where I can interject using my position, first of all as the Secretary of Public Prosecution, as a human being, as a mother and as a sister, I have used that position.
Thank you, Judge. My last question is on attitude, and because normally we consider attitude as very important for in leadership. So my question is, how does the attitude would affect? How would you use it as a judge if you become a judge? To do your job, to do a good job as a judge.
I think as a judge, I am expected to exhibit ability to be patient, to listen, and to value people and deal with them with dignity. So my attitude that is within me should help me to have values that assist me to treat people with dignity and respect.
So if I were to assess two judges in a council, what are these attributes I would look for to say Judge A has a positive attitude as a judge as opposed to Judge B? What are those, maybe 2 or 3 attributes?
Judge A, who has a positive attitude, will listen, will not interact unreasonably, interfere with the submissions of people unreasonably, will give people sufficient time to plead their cases, will treat people with respect. And if there is something that they are not happy with, they will not publicly condemn or deal with people negatively because it will interfere with people's image. So they will find time privately to deal with those matters if it is possible. And the same judge, if they want to say anything that is important, judges speak through judgments, but on personal issues and issues of character, there is nothing stopping the judge from interacting with the person who is involved, not in public, but respectfully.
Okay. Thank you very much, Senior Counsel. Thank you, Honorable CJ.
Thank you, Honorable CJ. Good afternoon again, Senior Counsel.
Good afternoon.
Now, before we embarked on this exercise, we had an engagement with the members, the representative of the Court of Appeal, just to get a feel of the kind of person they need in that court. And we also engaged other stakeholders, including LSK. And what the consistent feedback we got is that they want someone who is judge ready, someone who is able to hit the ground running, not someone who will have a long learning curve. Now, in introductory remarks, you mentioned that there's the issue of backlog, which you have the intention of coming to deal with. We have some case management strategies in the judiciary towards dealing with backlog. Could you share with us if you're familiar with them and what improvements you would propose?
One of the initiatives in the judiciary to deal with backlog is service weeks. And I thank you for that question first and foremost. To add on to what you were saying, I have noted that in the Court of Appeal, last year, 2,500 cases were filed. Out of them, 330 were criminal. And at the end of last year, they had a backlog of 8,000 cases. The disposal rate was about 2,000. And the pendency rate in the Court of Appeal has increased to over 20%, which means despite the bringing in of more people, the pendency rate is going up, the backlog rate is very high. So one of the things that I would do is to make an audit, to audit all the cases that are pending. There are tools that judges can use to look at cases that are dead, that are no longer viable within the system, to remove them. I would participate and encourage service weeks where judges concentrate on an area and within a week try to clear backlog. I would try as much as possible to use technology so that we can expedite processing, recording of cases, processing of cases, and at the same time the rule of first in, first out can be implemented. I would also be very vigilant about adjournment and unless it is very necessary, it should not be entertained.
Thank you very much, Senior Counsel. My next question concerns performance management. Is this a tool you use at the DPP? And if you do, maybe you can shed some light on it, how it works.
In the office of the DPP, we have introduced a software that deals with performance management. So at the beginning of every financial year, everything about an employee is fed onto the software. And we put in our targets, our priorities, and each officer will formulate their individual work plans, which is also fed in the software. So at the end of the financial year, we are able to get reports about each one of us. We have a department of quality assurance that it is charged with the responsibility to ensure that everybody meets their target, and that performance management is taken up by all divisional and departmental heads, and where there is a problem, there is sanction and reward. And as an institution, every year we sit as senior management, go through the performance management and see which areas the institution is supposed to come in, both for the institution and the individual. So we have a software that deals with performance management, but the managers are in charge.
Okay, thank you. That leads me to the next question. Which areas have you discovered using your tool that require intervention, as in the areas that you're not doing too well as a department?
One area that we discovered where we were not doing too well is that we found that the Office of the Director of Public Prosecution had about 5 tribes, 99%. So it did not have the face of Kenya. We have taken an affirmative action because of the work that we do, so that when we are employing, we have been deliberate to employ in areas where we are not represented. Because when we talk about alternatives to prosecution, plea bargaining and diversion, it is important that the officers we have on the ground can help us with the circumstances, the language of the people that we deal with. So we have taken an affirmative action to bring in other people in Kenya that were not properly represented in the office of the DPP to be part and parcel of the office of the DPP.
Yes. And which area have you done exceedingly well?
We are trying in that area. Another area that we have done exceedingly well is in capacity building and issues of welfare and human resource. Capacity building was supposed to enhance the capacity of the prosecutors to give them requisite skills to be able to deal with all the cases in court.
Okay, thank you. There was an issue concerning someone who wrote about a case that they had referred to you as secretary to the disciplinary board, but I have seen your response and I think I'm satisfied with it. I've looked through your documents, the vetting documents, they are all in order, so I don't have anything to raise with you for now, and I wish you well. Thank you, my lady.
Thank you, commissioners. I think the parting shot for me is a follow-up of what Commissioner Gishoi asked about working together with the other agencies, which you explained very well is taking place at NCAJ. But being a Kenyan and a Kenyan who looks at the newspapers, we are always seeing this part between the ODPP and the DCI, and this worries us because we know in this country, and you can correct me if I'm wrong, there is something called citizenry arrest. Is there?
Citizen?
A citizen can arrest somebody found committing an offense.
Yes.
And indeed they do this a lot.
Yes.
Especially in the villages. You are found defiling a child. It is the citizens who arrest you and take you to the police.
Yes.
There is also private prosecution.
Yes.
Where the DPP is the final authority in all this. So that even if this matter was taken by the citizen, even if it's a child who was arrested, the DPP can always come and take over. Why do we see this public war between the DPP and the DCI? in matters where the DPP can just walk in and take over the case. What's the problem?
Thank you so much, my Lord Chief Justice. Under the Constitution, the DPP has the sole authority to initiate prosecutions. And that is the reason why we came up with the decision to charge, because before we initiate a prosecution, we have to be satisfied that there is sufficient evidence and a reasonable prospect of conviction, and it is in the public interest. A citizen can arrest, but will a citizen be satisfied that there is sufficient evidence with a reasonable prospect of conviction and it is in the public interest? Article 157 of the Constitution calls upon the DPP to make sure that before he initiates any prosecution, it is in the public interest. And the same Constitution, with due respect, Honorable Chief Justice, provides that where Parliament confers prosecutorial powers to another institution, they will have those prosecutorial powers.
They will have to?
They can confer those prosecutorial powers.
Yeah.
So far, under the Constitution, it is only the Office of the Director of Public Prosecution that has been conferred with those powers. But the citizen is not interested whether prosecution is with the DPP and investigation is with the police. They want their cases to be taken forward. They want an effective criminal justice system, and they want a parliament that protects them, and where there is violation, takes seriously those violations and brings those people to account. I think for me the thing is that all institutions must work together to make sure that we gain our objective. My vision for the Office of the Director of Public Prosecutions and the criminal justice system is something like what is happening in Sweden now. The ultimate prosecution service should be able to deter such that you do not have cases going to court. There are no prisons. People are law-abiding, and all of us should ask for people to be law-abiding. So at the end of the day, the citizen is expecting an effective and efficient criminal justice system. And I think it is for all of us to work together to make sure that where there are differences, they should not impede what the citizen has bestowed on us to give them.
Yeah, I'll leave it at that for maybe a private conversation where we look at the big picture of what we want to attain and why two agencies would be fighting over who really should prosecute. And we know it's the DPP who should prosecute. Nothing stops the DPP from taking over those prosecutions, even if they are private prosecutions, even if they have been initiated by other agencies.
My Lord, with respect, the DPP, when he's exercising his authority, he should not act under the authority of anybody. So if somebody
else not acting under the authority of anybody.
Yes.
Just realizing that there is a private prosecution here, I need to come in and take it over. Nobody stops him from doing that.
A private prosecution is actually sanctioned by the court.
Yes.
And a private prosecution is provided for in
But
law.
he can come and say, I want to withdraw this.
With the authority of the person who has initiated the prosecution and with the authority of the court.
Of the court, yeah.
And with the risk of the accused person saying that there is delay,
yeah,
or that they have been subjected to double jeopardy.
Yes. So that's a big conversation in Kenya today, which the DPP needs to think through, especially because this is the big brother who is given the powers under the Constitution. So how do you exercise that power without looking like you are muscling everybody else along the way? Yeah, because really nobody can direct the DPP on what to do.
Well noted.
Yes, yes. So thank you very much for a very, very engaging conversation with the commissioners. We wish you well on behalf of the commissioners. I wish you well. But before we bring this interview to an end, we would like to give you an opportunity also to ask us a question or something.
I have no question, but I would like to thank you, Honorable CJ and Chair of this panel, and esteemed commissioners, for giving me this opportunity. I realize that being a prosecutor and being the Secretary of Public Prosecution is a privilege because I'm one amongst many. And secondly, I also realize that public office is a calling to defend the rights of people to access justice. If I succeed in this position, I will use my strength and experience to assist in upholding the Constitution, and also to make sure that the rules of natural justice apply in every situation.
Thank you very much, Senior Counsel. All the best. We will communicate with you when we complete the process.
Thank you.
Keep up the good work of
Thank you for
defending
having me.
Kenyans, defending the rule of law, and strengthening our institutions.
Thank you for having me. I
Okay.
appreciate it.
Yeah, nice afternoon.
Thanks.